Welcome to Lattes and Lattes, the podcast where we blend the world of law and business with a warm cup of information and common sense. I'm your host, Sidney Whelan, attorney, real estate investor, and business owner. Each week, we'll be your go-to source for legal insights, business advice, and so much more. Whether you're a seasoned professional, an ambitious entrepreneur, or simply someone seeking guidance, we'll have you covered. From navigating the legal landscape to empowering you with valuable business strategies, we'll explore the legal side of life and enjoy a virtual latte along the way. So, grab your favorite latte, get comfortable, and let's dive in to Lattes and Lattes. Welcome back to Lattes and Lattes, where we talk about life, law, and protecting everything you've worked so hard to build. I'm your host, Sidney Whelan, founder of the Whelan Law Firm, now serving North Central Missouri businesses and families in 3 convenient locations: Moberly, Carrollton, and Paris. Today, we're talking about something that might be the most important step in your entire estate plan. And it's also the step most people skip. And that is funding your trust. Now, I've talked a little bit about this before on this podcast, but today I want to delve a little deeper. I'm going to say something that might surprise you. Signing your trust doesn't mean you're done. In fact, if you stop there, your plan may not work at all. So here's the truth, a little reality check. A trust only controls what it owns. Let me say that again, because this is the entire episode in one sentence. If it's not in your trust, it's not protected by your trust. I see this all the time. People come in and they've done the right thing. They've paid for a trust. They've signed the documents and they've put it in a nice binder. And then years later, their family still ends up in probate. And why? Because no one ever moved assets into the trust. So today, I want to walk you through what, quote, funding your trust, close quote, actually means, and how to make sure your plan works the way you intend it. So what does funding actually mean? Funding sounds like a financial term, but really, it's just this. It means making sure your trust actually owns your assets or is set up to receive them. And that can happen in a few different ways. You can change titles to your property, you can update beneficiary designations, and you can assign ownership interest. So think of your trust like a container. Right now, you've created the container. It's called your trust. Funding, it is actually when you put things inside of that trust. So let's walk through what assets might be appropriate to put in your trust. Let's break it into real life, because this is where it starts to click. Your real estate. If you own a home, farmland, or rental property, any kind of real estate really, this is a big one. The property needs to be transferred into your trust by a deed. And if it's not, your family may still have to open up a probate estate just to deal with that property. So, if you own property in your own individual name or as husband and wife, we'll do a deed from you or you and your wife or you and your spouse as husband and wife or individually to you and your spouse as trustees of your trust. It's as simple as that. That deed has to be recorded, and in our office, we take care of that for you. We want to make sure that that real estate gets properly transferred into your trust. Okay, next, let's talk about your LLCs and your business interest. If you own an LLC or any kind of business interest, maybe it's a corporation, your trust should typically own your membership interest. That means executing an assignment and making sure that your operating agreement, if it's an LLC, allows for it. This is especially important for continuity, so your business doesn't end up in limbo if something happens to you. Next, let's talk about titled personal property. That can be your vehicles, boats, trailers, and the like. This one surprises people. Depending on your state and your overall plan, you may or may not want to retitle vehicles into your trust. Sometimes it makes sense and sometimes it doesn't. But ignoring it completely, that's where the problems can start. So let's talk about bank accounts and investment accounts. These are often the easiest to fix and, unfortunately, the easiest to overlook. Again, you can either retitle the account into the name of the trust, or you can name the trust as the payable on death beneficiary of your account. But if your trust isn't connected to those accounts at all, they are not part of your plan. Next, let's talk about life insurance. Life insurance doesn't pass through your will like other types of assets. It passes by beneficiary designation. So you need to be intentional about this. Should your trust be the beneficiary, or should it go directly to individuals? There's no one-size-fits-all answer, but there is a right answer for your situation. And this is something that you might want to talk to your attorney or your financial advisor before you do that. Non-titled personal property. This is everything else. Furniture, jewelry, firearms, equipment, personal items. These are typically handled through a general assignment document that moves those items into your trust. In our office, we handle that by having you sign an affidavit. It makes it clear to everyone involved in your trust that those assets are meant to be transferred into your trust and to be passed through your trust at your death. It's simple, but it matters. So what happens if you don't do this? Let's talk about the risk, because this is where I see families get blindsided. If your trust isn't funded, your family may still have to go through probate. There can be delays, costs, and court involvement. Your plan may not work the way you intended, and in some cases, it can even create confusion or conflict. I've seen families who did everything right on paper and still ended up in a situation they thought they had avoided. Not because they didn't care, it's because they didn't plan appropriately. It's because no one explained this step clearly to them. So let me give you some real-life examples. I've had clients come in after a loved one passed, holding a trust binder, saying, "Here, we thought we had everything taken care of." But the house was still in the individual's name. So despite having a trust, we still had to open up probate. And that's not the outcome they expected. And it's not the outcome they deserved. So here's the good news. This is fixable. Funding your trust doesn't have to happen all at once. You can take it step by step, but it does need to happen because at the end of the day, your trust is only as strong as what's inside it. And I want your plan to work when your family needs it most. So if you're not sure whether your trust is fully funded, this is a great time to review it. Pull out your documents, look at your assets, and ask the questions. Is this actually connected to my trust? And if you're not sure, ask. That one step can make all the difference. So thanks for spending this time with me today on Law Days and Lattes. If this episode made you think about your own situation, share it on your social media and with the other people in your life. It might be something they need to think about too. So until next time, my friends, take care of yourself and take care of the people you love. Have a great week.
This podcast episode contains general information for discussion purposes only. Each case is different and must be judged on its own merits. Missouri rules generally prohibit lawyers from advertising that they specialize in particular areas of the law. This show should not be construed to suggest such specialization. Nothing on this show should be taken as legal advice for any individual case or situation. This information is not intended to create an attorney-client relationship, and the listening or viewing of this podcast does not constitute an attorney-client relationship. The choice of a lawyer is an important decision and should not be based solely upon advertisements.